So we would like to address this in the second part of this session, the element which we are talking about most within our firms, and that is competition. We always complain about other people taking away, other firms taking away clients from us, undercutting our prices, hiring away associates. So we are complaining about competition, but what would we be without competition? We would get up late, we would not go to the office, we would not train our associates, we would not record our time. So maybe competition has some good elements, and it was Henry Ford who once said, if you are in a competitive environment, you have two possibilities. You lose, or if you want to win, you change. Now let's look at the areas where we need some change, where we discover in the marketplace that we need change. And what we have done is we have a distinguished panel from various jurisdictions and areas who can describe certain competitive situations and their reactions, which are typical occurring in their local market, but which have an impact on all of us and from which we can learn. So let's start with our host country, with Russia. And we have as a panelist Maxim Alexeyev from the law firm Allroot. He's a founding partner of the firm, and the firm is based in Moscow. And Maxim is very active in international transactions affecting Russian companies. As a second speaker, so as to control what happens in the Russian market, we have Andrei Gorodivsky from the firm Gorodivsky & Partners. He's also the founding partner of the firm, which was formed in the early 90s, in 1992, and he's also very active in international transactions. Perhaps, Maxim, you would start and give us an overview of the competitive situation in the Russian market and how you would react to fulfill Henry Ford's promise.
Спасибо большое. Я, честно говоря, не очень понимаю, почему наша сессия...
Thank you very much. Actually, I do not quite understand why our session is called Quiet Revolution, because I know that this city had several quite loud revolutions. And I would like to emphasize the following. First of all, the Russian legal market is quite young. And this market, as well as the whole general market in Russia, is slightly more than 20 years old. What does it mean for legal firms? There's a lot of new customers coming in. Where do they come from? From that business, from those businesses that couldn't afford legal advice before, and with changes of economic and political environment, sometimes people who are starting their business, they want to structure their businesses in an appropriate manner and to diminish their risks from the very beginning. So transactions change, and the approach is changing. The approach which is required to serve customers. Also, there are new practices that we didn't have in the past. These are medical services, for example, or sports customers, and so on. Russia is still a company which is quite attractive for investors, and we see there's a new generation of investors from the countries of Middle East and Asia Pacific region. They don't want to make the same mistakes as their predecessors, and they want to start their business, the relations here in the country in a different manner. And speaking about the Russian market, there is a trend which has been obvious from the very beginning of the market. It is strengthening and strengthening of legal departments of corporations. And this this trend started at the end of the 1980s, and you probably remember that when a new business was started, all owners, they wanted to have their own financial director and legal advisor. The professional level of specialists who work in legal departments of corporation has improved, and now they are more professional. They have experience of working in international and local legal firms, and they are excellent professionals in various areas. Moreover, great number of people who are directors of legal companies, they worked in international legal firms, and they know how pricing policy can be structured. At the same time, these people are very much aware of multidisciplinary tasks that even large departments of corporations cannot resolve on their own. And then this is outsourced, and these companies pay a lot for these complex multidisciplinary tasks, and very often the fee is paid on the hourly basis. And we did a survey recently, and we see that such works with hourly fees, the amount of this work is growing, and this is a trend, and we see that this budget and so on. Okay, now pricing policies. Is there a problem or not? On the one hand, yes, it is quite difficult, but on the other hand, it is not. Recently, again, we see a trend that more and more state-owned companies and big corporations, both Russian and international, they purchase services on the basis of bidding. And tenders are good, because even small firms have an opportunity to get interesting contracts and good customers. But at the same time, it means rotation of companies. Very often, in those corporations, those big corporations, they historically worked with a very small number of small companies. But now we see this rotation, and they are forced to change contractors. And those tenders mean that there's always a pressure to lower the price. And so we all legal companies, they have to carefully analyze where there are announcements of new tenders, what documents are required. So you need to adjust your standard presentations and your standard offers to those requirements that were set up by a specific tender. From communication with lawyers who work inside those corporations, we know that for them it is also problematic, because they have to analyze all that documentation and those bids. So this is the current trend, but who knows, maybe it will be over after some time. Another thing that was mentioned during the first panel, Russia is a part of the global picture, and within the last 2 or 3 years, we hear more, we find ourselves more often in a situation when companies say, well, we have a smaller budget for legal services, and they have to cut down their expenses, and they optimize their costs. Yes, definitely. This gives new opportunities for legal companies. So this may enable them to raise effectiveness of their services. Maybe they need to join some specialized sectors of legal services. There is another problem related to pricing. A big number of legal products that existed in the past, now they are standardized, and partly they can be prepared by companies themselves, for example, by legal departments of those big corporations. And or this service is purchased at a quite low price, and this can be done by new small companies or by international companies who have this work sort of subsidized by their parental companies. Anyway, there is a niche of complicated, integrated projects, multidisciplinary projects, and this enables a legal community to get their income and to provide services at normal prices the legal business is accustomed to. Also, I would like to draw attention to another trend. So there are additional expenses for development of new software and new technology in order to raise effectiveness and productivity. So they have to develop and introduce plans of continuous support and various new filing and databases, systems, and so on. What else is typical for the market? Definitely, there is a pressure from new startups. And we see that there are more and more companies like that. Part of those companies they appear within big Russian companies. Some of them they are formed on the basis of big international companies, and at a certain point they have to make a decision how to develop in the future. And for us, this will be interesting to see what decision they will take and how it will affect the market. In experts' opinion, Russian companies have slowed down their development, so the pace has become slower, and we see that lots of spin-offs. There are lots of spin-offs, and this can be explained by the fact that these companies do not correspond to the level of legal and regulatory area development. So these companies, they do not correspond to the overall context, legal context in the country.
And I think especially what you were referring to with the spin-offs is also an effect which has to do with the regulatory situation in Russia. And Andrei, what can you add on this in particular?
Добрый день, уважаемые коллеги, мои друзья из других.
Thank you very much. My friends from other legal firms have told you so much about this market, so I would like to touch upon the major things, the revolutionary. So we need to speak about the revolution, finally. So, in this context of a revolutionary situation, I need to speak about those challenges that we expect and partners of legal firms in Russia can expect. We know that in Russia there are never quiet revolutions. It is always loud and with a bang, because this is specific, because we've been dormant for 20 years, and and now we need this revolution. We see that there are relations. And okay, so that Aurora shot, we had it already. If you don't know what that is, then you need to study our history of 1917. Right, so the government approved in March program called investments, and partly this concerns reformation of legal services. This program is very wide and it covers various areas, but we are interested in this. What two statements I would like to stress there? First of all, this program is saying that there will be a monopoly of lawyers to represent clients in court, and the second concept is that all operators of legal services in Russia need to be united into a corporation or into something. What are challenges for Russian companies here? As for the first statement, I, as a lawyer, I should be interested in this, but I believe that just making the statement that only lawyers can be authorized representatives of clients in court, if this happens, then it will mean that for us, for partners and executive partners of legal firms, this will mean that we need to prepare that we might have so many different customers and so much work. And viewing the situation in the market, I don't think that we need to reject this work, and depending on our specialization, still need to be ready and practicing lawyers, they all have a code of ethics, and following this code, we have to get ourselves ready that all this burden will come to us, and it obliges us to prepare infrastructure, so our offices, and we need people who will communicate with those clients, and also we need to develop methodology how to participate in those cases we didn't work with in the past, and we need to get ready that these customers will be diverse, and very often these will be customers we have never worked with. The other, regulation of the market, the second statement. This topic has been discussed widely in this forum and last year, and there were two deputy ministers of justice and the minister of justice himself. So for several years we have been discussing it, and now we have this topic, and this was reflected in that program issued in March. I believe that there is no reasonable alternative, and this unified cooperation or association, this is reasonable, and it is in line with the logical approach towards our work and regulation of the market, and it is in line with all international standards. I don't think that you will demonstrate any country to me, and even if such country exists, then it will be an exception. So advocacy, so this is used everywhere, and about 70,000 of our colleagues who don't have a status of a lawyer, they need to join our community. And in terms of the revolutionary nature of our life, our law is not ready, the station is not ready, because they have their own relations, and these structures cannot become lawyers, these advocates, and this will ruin the whole system of relations existing nowadays.
The challenge that we are facing now is to set up a modern law on advocate practice, barrister practice, and more specifically regarding regulating the forms and ways of practicing advocacy. Well, by creating those forms, we should always have in mind that about 70,000 of our colleagues who are professionals by and large should be able to easily, seamlessly, to the extent possible, to become say, members of the Bar Association. And in this context, I think that for partners of legal firms, the challenge is that the community should speak with one voice, should consolidate itself, should develop its position on the issue, and should make a statement, state this position. This attempt is made through the channel of non-governmental, non-commercial partnership created by 10 law firms, but we need support from the entire legal community. The role of a partner or a managing partner in a law firm is to have visions, is to create future, develop a strategy for his or her legal firm. So this applies to a specific legal firm, but a legal firm does not exist alone in the field. So we are speaking about a pre-revolutionary phase when we are going to develop piece of law which will regulate the market where we operate. Until this moment, we have not had such law if we do not say take into account the old law on advocate practice, which played a positive role at the beginning of the 90s, but now it's become dated. And that also deals with the second part of the 70,000 people. The next issue which I would like to dwell upon right now, which in the situation of competition is very topical. Andrei Gosbert mentioned one of the form of developing of the legal business in this country. I do not claim to be able within a very short period of time, given the short small budget of time, will be able to address other tools, but still I would like to mention only one of them, is the various unions, associations, and whatever name you may want to choose for that. We should once again remind ourselves the words of Andrei, that until now we see a situation not of non-consolidation, non-unification, but rather segregation or separations from the legal firms. Certain lawyers who set up their own legal firms. The phenomenon is an unnatural one because the market is tough and tight. Well, we should rather be consolidating rather than disintegrating. Well, but the Russians always have their own ways, but I would not, in this case, explain it by the so-called mysterious Russian soul. We should simply go through that phase in our development of our industry. One of the stalwarts of the Russian revolutionary movement said that before we should unite, we should separate. This is, I think, a phase which we're going through. So by the time will come when we start to unite, and I would be very happy to see this happening there, and then we'll have to overcome the peculiarities of the Russian national character, where emotions quite often prevail over reason and pragmatic approach. We should take lessons from our British and American colleagues when they, being sufficiently high professionals, happen and can find to find a common language when 50, 60, 100 partners can do business together even in the situation of difficult economic situation, is a global business, and they're quite comfortable to do that business, being numerous in their midst. So I think this is something which we should try to learn to do, and that is the way for a great number of Russian smaller legal firms, law firms, to go. I believe that we may also look at some international consolidation, but that will depend to a great extent on the new law and the provisions of that the new law will have. Coming back to deficiencies of the present-day legislation, I would like to say that on top of those issues which we face in the psychological domain, we are in a situation which is unacceptable from the legal standpoint to make unification. So a barrister bureau cannot get united, merge rather, with another company who works next door, but which has the legal shape of a limited liability partnership. We're speaking about the provisions of the existing law. Now we're in situations when we simply are not able to do that. I always try to address pragmatic issues, and the future of this market depends on the extent to which we'll be able, not only internally, not only through on the basis of our conviction that our business can move forward and flourish, but also considering the external, circumstances, create new, more serious and more stable and more effective structures. I don't want to touch upon the issue of that the market requires narrow competition of specializations. Boutique legal general practice lawyers are not so effective these days from the standpoint of conducting a business, and the market calls for specialists, narrow specialists, working in a team with a with a good infrastructure, supported by infrastructure. This is something that we have learned over the last 20 years or so. Well, the crisis may not frighten us. They may somewhat gloom our day, but they will not frighten us to death. No one remembers all of the crises that we have gone through. We have somewhat adapted to the situations. They are not a pleasant thing to go through when we see that the estimated gross domestic product drops from 4% to 1%, so we are a derivative from the economy, and we cannot say that we have the best of lives by the economy is in the stage of recession. We are, hostages of the situation, of course, but the another challenge for partners of legal firms is that they should formulate a task for themselves to go through the situation with as little blood shed as possible, or rather even use it as an opportunity for growth. And for that, they need to feel themselves as owners of their business rather than appointed managers or appointed partners. Sometimes, well, I understand that partner is a co-owner of the business, and if he or she is the owner or co-owner of the business, he is supposed to preserve that. He can see the future, can believe in the future. Thank you.
Thank you, Andrew, for the insights into the Russian Reform Act, and also the fact that there are a lot of spin-offs occurring, and the differences between the barrister regulations and the regulations for the simple advisory form of legal advice. Let's now turn from Russia to England and Wales and introduce Lucy Scott-Moncrief. She's the president of the Law Society of England and Wales. And beyond that, she also runs a virtual firm, a firm with no firm office, and it's engaged in mental health and human rights aspects. And Lucy will most intensely introduce us into the ABS structures, the alternative business structures in the UK.
Yeah, in 7 minutes or less, I believe I've got. I'll do my best. I set up and run a firm with about 55 lawyers in it, and I set it up 26 years ago. For many years, we only did legal aid work, and legal aid is still the main part of our work, but we also now do some private client work, employment, personal injury, wills and probate. As Homer mentioned, we are a virtual firm. All our lawyers work from home or from their own offices, and that includes me. I work at my kitchen table, very nice view over my garden, and they're all self-employed. And this structure was set up to respond to competition. Not competition for clients. There are not that many firms that do legal aid anymore, and we have no difficulty getting clients, but actually competition for staff. Because legal aid work is badly paid, and there are sort of two ways of dealing with that. And one way that a number of firms have adopted is to employ unqualified or newly qualified staff under supervision to do this work. But we didn't want to do that, so we went the other way and thought, well, if you've only got a certain amount of money and you want to give most of it to the people who are doing the work, then you need to cut your overheads. And actually, the virtual model allows us to do that. It's not true that we don't have an office at all. We do have a basic administrative office, which is about the size of this platform, and we've got 3 people in there. Because that's all we've got in terms of office space, and because everyone's self-employed, our overheads are really, really low. And we are very, very flexible in the way that we can grow and shrink, because if somebody wants to join us, so long as they're a good enough lawyer, so long as we're satisfied that they are self-motivated in the right way, then we can take them on. We don't have to find another room, we don't have to find another desk, we don't have to find another secretary. We just take them on. And equally, when people leave, we don't have surplus office space that we have to try and then fill or sublet or whatever it might be. Very, very flexible and very, very cheap. As a result of this, the norm in law firms in the UK is that an individual has to earn 3 times their salary. So they get their remuneration, they get their salary, and then there's another third for the overheads, and then another third for the partner's profits. We've turned that upside down, and the people in my firm keep 70% of what they bring in, and the 30% that's left has to pay for all the overheads and partners' profits. So partners are very keen on keeping the overheads down, as you can imagine. And the way that we do this, I mean, we do use technology, but not obsessively. Most of the people in the firm are not of the internet generation. You know, I still don't know how to tweet. But, you know, we've got an intranet. When the post comes in, it all gets scanned out again to people. We have a case management system, so the post can be put onto the system, so it's all there in the computer. So at the end of the case, the fee earner can just press a button and the bill comes out. We're on the cloud, so we can do our work wherever we are in the world. And we have IT as a utility in the same way as our phone bills or our electricity and so on, which means that we pay a fixed sum, fairly small sum, every month for each lawyer to this organisation, and they run all our IT and they update all our IT, and we never have any surprises there or extra costs. So it's all kept very, very low. And what we've discovered is that we are providing a service for a group of lawyers who weren't really having their needs properly met in more traditional firms, because we've discovered this sort of vein of lawyers who they don't want to be bosses, they don't want to be business people, they don't want to be owners, they don't want to be managers, but nor do they want to be associates. They don't want to be wage slaves, they don't want to be employees, they don't want to have to clock in, they just want to be lawyers. And they don't want to be sole practitioners, because that's all the sort of burdensome. So they just want to be lawyers. And by coming to us, and because they're self-employed, they can just be lawyers. We don't have billable hours targets. Any work that somebody takes on, they have to do to our standard, but they don't have to accept any case. If they go away, they can go whenever they like, so long as their work is covered by somebody else. You know, we have sort of procedures and policies for all those things. So it's the sort of last degree in flexibility, and works extremely well. I'm a fairly early morning person. I send a lot of emails at 6 o'clock in the morning. I've got colleagues who, start sending their emails at midnight. Well, that's all right because we're all linked up. We've got an intranet. So it's a very, very flexible system. We never have to advertise. People come to us because they want to be able to work in this way because it allows a good work-life balance. And we have also sort of rethought what the purpose of the firm is. The work, certainly the legal aid work that we do, is difficult work. We work for life sentence prisoners, we work for people in psychiatric hospitals, we work for locked up and looked after children and young people with complex needs, as it's politely called. So it's emotionally demanding and complicated. And so we see our role as supporting our lawyers as best we possibly can so that they can do good work for these difficult clients in crisis. So we put a lot of effort into cutting down the amount of unbilled work they have to do, the amount of administration that they have to do. We provide the technology that allows them to minimize the sort of administrative burdens of any kind of casework. We carefully keep up with regulation and let them know what they need to do to be compliant with regulation so they don't have to keep up with it, we do it for them. And so all they need to do is to do the work and keep up with what we tell them. We are extremely traditional in lots of ways. We have units with supervisors, we have unit meetings, we have file reviews, we have annual appraisals, we even have office parties, usually in somebody's garden, my garden very often. So, it is in that way very, very traditional. If you looked at our office manual, it would look the same as anybody else's office manual, except for those two things: self-employed, don't work in the office. And all of this was within a traditional partnership structure. Oh, I should also say that we're building up our non-legal aid work. And of course there, the competitive edge for the people doing that is that because the overheads are so low, they can offer a cut rate. They can be very competitive on price because they can still earn a decent living out of their 70%, and the 70% can be a good deal lower, and people can charge whatever rate they like. We don't set the rates that they charge. They can charge whatever rate they like, and they have this competitive edge. There's a lot of unmet need in the United Kingdom, unmet need for legal services, and it's often unmet need because people can't afford it. Traditional legal services can be very expensive. So this is a way of actually expanding our client base by providing affordable services to people, but by providing it from very experienced lawyers. As I was saying, this has all been done within a traditional partnership structure. But actually, I have decided to convert the firm, and in fact, our regulator has agreed to allow us to do it, to an alternative business structure. Now, without going into a huge amount of detail, I know there's a lot of sort of anxiety about alternative business structures, but at the heart of it, there are two things that are important. Firstly, in an alternative business structure, what the regulator is looking to be satisfied about is that the structure protects the independence of the lawyers working in the organisation and protects the interests of clients. So that's number one. And there's a whole complicated procedure that you have to go through to prove that that's what you're going to be able to do. Number two is alternative business structures are regulated in exactly the same way as traditional practices. So the reason why somebody would become, or a firm would convert to an alternative business structure is not to get easier regulation or cheaper regulation, because that won't happen. It's because it suits the business. And the reason that I've done it is this, and once again, it's a competitive reason. I've been banging on about virtual for years and years and years, and suddenly I've got competition. There are other virtual firms out there, including virtual firms doing the same sort of work as mine, although there are also commercial virtual firms, which I think is a really exciting sort of possibility of bringing individuals together. But anyway, not talking about commercial law right now. And so there are these other firms, and there are people might want to go to them or might want to come to my firm. But what I also want to do is I want to retain the good people that we've got. And the trouble with the system that we've got at the moment of self-employed consultants is that they have no opportunity to share in the success of the firm because they're not partners. and they're not going to be partners, and they don't want to be partners. And under the traditional structure, if you're going to share in the profits of the firm, then you have to be a partner and you have to take on a lot of regulatory obligations and management obligations, which is burdensome, and it also puts you at risk because you then have to get involved in partners meetings. I don't know how many of you enjoy partners meetings, but I've never met many people who enjoy partners meetings. No, you don't. You were just putting your hand up. What we've done, we've converted the firm into a limited company, just an ordinary limited company, not a specialist limited company, an ordinary limited company with shares. Now, I'm only going to let people in the firm buy those shares, or possibly their husbands or wives or whatever it might be. So it's going to be a very tight group of people who are going to be able to buy the shares. But by buying the shares, they will have a share in the profits of the business without taking on any of those regulatory burdens. And equally, I'm hoping that the opportunity to share in the profits is going to give me the edge when people are thinking, well, shall I go over there or shall I go over here? So alternative business structures, to me, I know that there are obviously some that are sort of a competitive threat, but for me, being able to turn my firm into an alternative business structure is a competitive advantage. I think that when one is thinking about alternative business structures, you have to think about the reality of what this is going to mean, rather than the sort of the bogeyman of this is the end of legal practice as we know it. Nothing's going to change about my firm in terms of the standard of the service we offer. It's going to look exactly the same. It's going to feel exactly the same. There's just some change in the machinery around the back. Yeah, that's it. Thank you.
Thank you, Lucy, and for the insight into virtual firm and alternative business structures. We now want to turn, before we have the discussion, into two strongly growing markets and very dynamic markets, which is first Turkey and then India. And I would like to introduce Sidika Baysal Hatipoglu from the firm B&B Hukuk Bürosu. Thank you. In Istanbul, a growing young firm, and Sidika is the managing partner? Yes, founding and managing partner. And she's also very active in the IBA as an officer of the European Legal Forum, and she is specializing in e-commerce law. Please tell us about the competitive challenges in Turkey.
Actually, in Turkey, we always had like White & Case and other big law firms for a long time, actually. But they were coming to Turkey like, not like a law firm, but they were setting up a consultancy firm because there was not a chance for them to set up as a definitively law partnership. But in the recent years, we had a change on the Lawyers Act of Turkey, and the foreign law firms can also come to Turkey anymore and set up their own law firms. And taking into consideration the latest economy of Turkey, we have maybe in the last years, we had more than 10 foreign law firms coming to Turkey, actually. So this means a very big competition, and I used to work for one of the international law firms for 4 years as a partner. And before in the previous panel, we were also discussing about the cultural issues, and I really would like to make some points about this maybe. Turkish people are a little bit Mediterranean, we have our own temper, and I used to work for a German law firm, and sometimes, I was getting emotional, and my other Turkish colleagues were getting emotional, and the German colleagues wouldn't understand that, because they are so disciplined, they have the technique and so. Now, with my new law firm, which I set up 2.5 years ago, I have an Italian partner. We are getting on very well because they have their own temper, emotions. We have our own temper and emotions, and we get along quite well. I just wanted to make this, When we come again to the competition we have in Turkey, if the law firms, some of them just set up, yes, as I told, as a law partnership, and we have a very strict advertisement ban in Turkey, unfortunately. I say unfortunately because being a lawyer still is considered as a public service. at the end of it, I'm earning money out of it, and it's a commercial thing. And I think it has to change. You know, we have to explain it to the bars very efficiently. But nowadays, I don't know if you are aware of it, but they are a little bit under political influence, and the president and the board members of Istanbul Bar are today being sentenced by the criminal courts for supporting, you know, just some people, journalists put in jail. So they are not very much interested in those kind of advertisement bans for the time being because of dealing with these criminal things. That's a good thing maybe, because if you set up the law firm, depending on the Lawyers Act in Turkey, you have the same ban actually. Let's say Elena Novri came, Clifford Chance is in Turkey, White & Case has been forever. So they have the actually ban on advertisement too, if they set up as a law partnership according to Lawyers Act. But if you just choose to, there are also law firms, I don't want to mean that Clifford Chance, Elena Novri, White & Case is doing this, but it's like an unfair competition. They set up a general joint stock company, and they are just out of every ban by just establishing this. So this creates a problem for the local firms, I must say. Apart from that, you know, we have also competition with the spin-offs. I was one of the spin-offs as well. You know, we set up, and there are all like spin-off young companies. And as far as I think, choosing a niche subject, if you are, you know, just a young law firm, and if you want to differentiate yourself from the others, you should be choosing yourself a niche topic. And our topic has been the e-commerce. We are maybe, you know, although we have been set up 2.5 years ago, with 4 people, we were also like entrepreneurs, startups at the end of the day. It was like a boutique law firm, but we are now more than 25 lawyers and expanding. Maybe, you know, the entrepreneurship spirit of our clients is passing to us, most probably. So by having this and also having a relationship with the Italian law firm that I mentioned before, they were 2 niche points for us to be differentiated from the other law firms. So in terms of competition, it was a good start for us from the beginning. And I think it will go on like this. And I totally agree that we have to be taking care of technological, we have to be involved in inventions. Maybe we are innovations. I am personally using Twitter very efficiently. It doesn't mean that I have thousands of followers, but still, in my case, I am using it. And I really think that this is the new way of marketing and advertising, and every law firm has to use it very efficiently. Apart from that, I have never been a lawyer. Let's say, okay, I will earn thousands of money, but I will not have time to spend it. So I was like this when I was an associate, and now I'm the managing partner, and I don't really want my lawyers to, just to work, to earn money, and can't find to spend time on it. So our, just office is in terms of finding talents, because it's also very difficult considering that there are a lot of foreign law firms coming into Turkey. We, I think, have a very good work and private life balance in our firm, and it attracts very good, talented people into our firm. Unlike we think that most of the young lawyers, they work for money. Yeah, actually, it's okay working overtime. I was one of them. I really liked it in the beginning, because you have to learn something, and actually I cannot see it from my current new lawyers. They don't have that, so they are discriminated somehow, even from our law firm, because you have to be willing to learn something, you have to be passionate. And if you don't have this, you are in difficulty. So this is an important point. We don't work in the weekends. We just start our working hours is 9 o'clock. Most probably, we will finish by 7. Apart from that, I'm saying that I'm like the chief happiness officer of our firm because I set up yoga lessons in the firm twice a week in the weekdays. We come early, like 8 o'clock in the morning. One of our lawyers is a yoga instructor. We start the day with yoga. So after that, we have a very nice breakfast followed. And, okay, half an hour late, we start working. Not all of them, of course, it's not a compulsory thing at the end of the day. Whoever wants, they can come. The second thing, now we are setting up a rock band. We are bringing low rocks in Turkey. I'm in charge of it. I will be the drummer. I'm taking drum lessons. And our colleagues, one of them, even, just one of our older, let's say, partners, she said that she would like to play bongo, on the stage. So these kind of things also, I think, makes the employees happy and the colleagues happy. And if they are happy, they work very well and effective in an effective manner. And, this is my, of course, personal opinion. I don't know if it will be valid for all law firms. But this is how we deal with things in Turkey, my law firm. This was my personal experience. Thank you very much for listening to me.
Thank you for sharing with us the innovative approaches you were describing, and I think this will, of course, foster competition. Let's turn to another interesting and growing market, India, and let's welcome Nishit Desai from Nishit Desai Associates with offices in India, Singapore, Palo Alto, and soon Germany. And Nishit Desai is the founding partner and managing partner and has received many awards in the region and beyond that. Nishit, what are the competitive trends?
I think everything that, my name is Nishit Desai. If you can't remember my name, you can remember as Mr. India. And I think what has already been said, everything is very relevant. As you mentioned that we are a law firm, we describe ourselves as India-centric global law firm. We have two offices in Mumbai, one in Bangalore, Delhi, Palo Alto, Silicon Valley, and Singapore, and one more in Munich coming up on 1st of July. I've been listening to a lot of expressions, for example, global law firm, and I believe that everything has a definitional context. So when we say global law firm, there are law firms, there are international law firms, there are multinational law firms, but globalization is a matter of mindset. And therefore, a company can be a global even without having a single overseas office. So how do you, it could be technology driven, it could be otherwise. As far as I'm concerned, I'm the founder of my firm. I founded it in 1990. But before that, I studied almost 100 odd law firms, different organizations, and including accounting firms inside out, studied histories of these organizations, and firms like McKinsey helped us to build a law firm. That was way back in 1999. After studying all the law firms, I found one clear message that if you want to be in the game, you have to be a strategic player. And strategy is nothing else but a differentiation you create, which differentiation, even if known to others, cannot be copied. If it could be copied, it is a tactic. It is not a strategy. So first of all, you have to differentiate in a number of ways. I also heard a lot of comments on pricing, and I will deal with that in a moment too. So in any business, there are 4 dimensions, what we call balanced scorecard. You have clients on one side, you got people on the other side, they are connected through processes. And if you balance them properly, then finance is only a lagging indicator. Okay. So let me just walk you through a little presentation that I have. I won't take too much time. I know you have a lot of hunger for knowledge, but I will be happy to share my experience rather than teaching. Maybe you can see there. If no, oh, I'm so sorry. Don't worry about it. You see, basically, this is about the evolution of the law firm. But first thing I see all the time is on pricing competition. Now, first of all, as I mentioned, you must understand the definitional context. Price is different from value. So when we create any differentiation, it has to provide value, if at all you want to compete. And we do not believe in competition, we believe in competition, cooperate and compete. I think I'm just talking the number of what you call contrarian view that we took. So we love working with competitors, we respect competition, and we enjoy competition because today competition is the biggest stress creator in the world. And if you treat it as a sport, you will enjoy. If you treat it as a war, many of the American friends have taught me different jungle words, such as competition is a war, head hunting. We never go for head hunting as a matter of policy, and we got the best of the realm and stuff like that. So first, evaluation is a matter of opinion, as we can, see that. Price is a function of demand and supply. Valuation is a matter of opinion. So you have to deal with perceptions. When you deal with perceptions, you have to understand the organizational psychology. Many a times nowadays, these organizations call for bids. We are bidding for legal services. We have been dealing with mostly large, complex, Fortune 500 or global companies all the time. And first question I asked to a general counsel is that when your CEO requires a medical surgeon, do you call for bids or you go for the best, okay? And therefore, there are many ways in which you can psychologically impact the decision maker because behind every organization, there is a human being. There is a human being behind, oh, next slide. I'm so sorry, it's not being seen here. Can you change to the next slide? Yeah, price. And the next one is understanding organizational psychology. Next one, behind every organization, there is a human being. So you have to address that part. Number two, next slide. And very interesting book I came across in early time when I set up law firm called Discipline of Market Leaders, which is shown on the next slide. It says if you want to be a market leader, you have to choose your customers and narrow your focus. This book I suggest to all of you to read. And number two, whether to become big or to become small, I think you have to decide. There are two models. One, let us call in a lighter vein, a Walmart model, or you can become Louis Vuitton. It may be small, but you can create different value. Okay, and I will give you some statistics about the law firms in the world, if some of you are not aware. And if you look at the largest law firm, I believe today, of course, beside DLA Piper, I do not know the statistics, but at least the 2010 ranks, Baker and McKinsey, they have 3,774 lawyers. Per lawyer revenue is $558,000. Smaller than that is Clifford Chance with 2,586 lawyers, but higher per lawyer revenue, that is 725,000. Next one is Linklater, it is still smaller. It's 860,000, and there is a firm called Wachtell Lipton with only 248 lawyers, and their per lawyer revenue, not per partner, is 2.5 million. That is 5 times the largest law firm, if you put it. So does it mean that does size matter? Probably not. So therefore, it's very important that you have to create some kind of distinct differentiation, and you can create a number of times more value than what you call. So the approach we took was threefold: strategy, law, and tax, because tax became a very big differentiator for us. We are international tax lawyers, and as a law firm, we have been competing with 100-year law firms, we've been competing with accounting firms, we've been competing with international firms when they have collaborated with Indian firms, but consistently we have been termed as best performing law firm in India. Again, one approach we took was research, academics, and thought leadership. We spend almost 35% of our time on research, academics, and thought leadership, and I won't go into too many details because time is running out. What we looked at when I studied all these 100-odd law firms, and they had history of 100 years, they are big, etc., whereas we are starting a new kid on the block. So we said, how they can look back and see that with a pride that, okay, look at, we have 100-year, 200 history. Now I can't, I'm a little kid, so what can I do? So I said, okay, my strength is to look future 100 years. And based on that, we build a firm, just as you build on e-commerce and stuff like that. So we believe that every new technology, every new financial instrument, every new business model brings along with it a new legal or tax problem. You look at Wi-Fi, WiMAX, quantum computing, e-commerce, nanotechnology, fuel cells, quantum computing, every single one will bring a new legal or tax problem. So we identify trends, we do trend assessment and forecasting, then we do research on what are the likely, we do a lot of imagination and see what will be the new legal or tax issues that will come up. For example, in 10 years' time, you will have remote surgery happening from, say, US, somebody sitting in Houston will be operating on an Indian patient without even coming into India. Lawyers sitting abroad will be able to practice Indian law, even the Indian Bar Council may say anything about it, but they can do a lot of things. So now, if you perform activities overseas and something happens to a patient in India, where will you file a lawsuit? Can he practice on an Indian patient? What happens if he dies? And stuff like that. So we do a lot of those, and if at all any payment is to be made, whether there is a withholding tax, because tax is a huge issue in all countries. So whether a doctor to be paid in Houston, you do withhold tax. So we look at from that perspective, and what we do, therefore, the process is anticipate. I'm sorry, can you, next slide? I'm forgetting to do all that because I'm in a rush. Can you go to the next one? Next one. This is the research slide. We spend, as I mentioned, almost 35% of our time on research, academics, and thought leadership. And anticipate, prepare, and deliver is the model. Anticipate what's going to happen in future, prepare today, and deliver. In the process, we not only do secondary research, but also do primary research. So our team goes out in the world, interviews industry players, understands on the ground, comes back, prepares report, and stuff like that. I'll be delighted to, discuss that approach if somebody is interested in the whole stuff. And another thing that you need to do is to do strategic branding. And what I call strategic branding is that we all talk about, oh, we did this big deal and we did this deal and stuff like that. We all do that, billion-dollar deals, okay? But one thing we became extremely known for was that with small teams, we do very large deals. Half the time we do hundreds of millions of dollars deals, and people are surprised that how do you do with 2 people, 3 people? And one, I think I'm given the signal, the way in which we address this issue was through training and education. We have every single morning, you talked about yoga. In India, yoga is not one type yoga. There are a number of types of yoga. One of them is karma yoga. Karma yoga means work yoga. When you work, it itself is a yoga. Of course, I do myself also physical yoga. But really, every single Indian would know about what is karma yoga. Okay? So karma means work. So we start our day at 8:30 with training on balanced scorecard, management training, because many times lawyers become good lawyers, but they are not good managers. So you need to train them on that as well. So 8:30 to 9 is that training. 9 to 10 is a technical legal training, including with the case studies of different kinds. And we studied a lot of knowledge management and training modules. And I like one of the modules, what is taught at Harvard Business School. It is inverted T, it's reverse T. So everyone must have 1 or 2 specialized focused area, but they must have general knowledge of other things. So every day we have a continuing education program. I do not know any other law firm here does it or not, but 9 to 10, every single morning, we have a continuing education program, including I have to attend, and our rule is that, I'm sure Russia will like it, if you're 1 minute late, it's considered half a day leave. Okay, so that's how we have developed a very balanced portfolio, I would say, of the firm members who are almost on the same page as far as information is concerned. There are no conflicting opinions but given by different offices and stuff like that. And third thing that, as I was mentioning about strategic branding, next page, please, next page, strategic branding. One of the most important things, I'll just finish in 1 second. But he's a little slow, I'm sorry. So, an Indian's always been Indian 1 minute. But can you take to the next slide? Okay. So, strategic branding is that you have to demonstrate to the society that you do something larger. So, in terms of social and projects and stuff like that. And we develop a very strong branding on being a socially responsible organization. I think that has really helped us. And as I mentioned, that another last thing that we have done, which all of you will love, and that is, next slide please, next slide. That is staying right size, I talked about it. Next one, yeah, happiness billing. So this is the last thing. So we said strategy is a differentiation you create, which differentiation, even if others know, cannot copy. So we have introduced system of happiness billing. Like in the US, you go to any store, you can return goods, if you're not happy, give it. So we developed a billing policy, which we said, we are a little more expensive. Let us not be, vague about it. I'm not saying expensive is a matter of perception. But we said, yes, but if you are not happy, don't pay us. If you are happy to the extent to which you are happy, pay us. And if we are not happy, next time we will not take you as a client, but will not give you up half the way. So I think this experiment has also been working well in a number of ways. And in India, we are very philosophy driven. So we believe in happiness. And happiness is never straight line. It's only up and down every second moment. I'm sorry, you can see my excitement on happiness. But so happiness is always up and down curve. Every moment you are happy, unhappy, happy, unhappy. Only time you are happy in the life is when you are dead, when a cardiogram will come straight line. Okay? So I think happiness billing model is another way to compete, because when people compete on price, only way in which you could say, you are a little expensive, but don't pay us if you're not happy. And with this, if you do not want to listen to me anymore, I will stop now. And thank you so much. Wonderful this evening.
Thank you. Thank you for your thoughtful insights. I think it's so important to be competitive, but happy in being competitive. That's the element of it. And then we all stay happy and don't get sick. But now we are for questions. I think we got a lot of ideas to discuss, and the time is, of course, limited. But who wants to be the first? Please, please.
Thanks. Thank you very much for a really interesting afternoon. It's Caroline Sexton, Ernst & Young. Just briefly, sorry, I'm not holding it correctly. In terms, this question is really for Andre, actually, and also Sadiqa. The virtual law firm model, how would that work in the context of your local legal market? Does that already operate? And do you see that being something that could be more widely distributed in your local market? And the second question actually is for Andre specifically. How might you incentivize the 70,000 non-lawyers that are providing legal services to join an association like the IBA to help promote and foster, standardized legal services? Thanks.
Let me answer your second question. We have 70,000, approximately 70,000 members of the bar associations. They are lawyers. It's me, for example. Okay? And we have also about 70,000 practicing lawyers who are not members of the bar. In our country, it's a wild democracy, so everybody can provide legal services. No requirements, no licensing. Even my driver can start tomorrow providing legal services because he is 10 years with me and have heard something about the law. So, but I'm not talking about colleagues who are really do wonderful business, but they are not members of the bar. So I gave you just a whole general description of what's going on here. So absence of any unified law with respect to the professional activity. Only one law which is applicable for attorneys, members of the bar. So what we have. And this law, according to me, at least my understanding, should be modernized. But it seems that the government now is thinking about overall regulation of the market. And this is exactly a revolution for us because 20 years we've been living without this, and a lot of financial property relations have been established in these law firms which are operating on the market. And now, when they would like to introduce a new law, well, sorry, but somebody will suffer. The first question.
May I add a word? I think you spoke about virtual organization, virtual law firm. We have developed a platform for web-based legal services, but to more complex deals. Because there are two kinds of levels at which you can operate. You can have legal source outsourcing and many of the technology enable. But the way in which we are looking at ourselves is to do high-value, complex deals. And this is the web-based thing. Unfortunately, internet is not working right now. But you will see this web has to start with number of different features. You can go and visit nishiddesai.com. But one of the things you can clearly see is nishid.tv. And there are 4 channels. One for public, one for students, one for clients, premium clients, and one for the firm members. Education is a gateway of marketing, if you put it this way. Sharing experiences and selling stories is a great way to marketing. If a small firm wants to take on head-on the big firm, generally big firm spends a lot of money on glossy brochures and a lot of other kind of expenses. You can do effective marketing only by selling good stories, and that newspapers will publish, and that's what we have effect. We hardly give advertisement ever, in spite of the fact, of course, Indian law does not permit that, but when you're competing with accounting firms and global firms and other ones, one of the things is, so we have 4 channels, unfortunately I can't show them, and there are NDA Connect, or there is NDA Cloud, there is NDA Extranet, NDA Intranet. Almost everything you can do virtually, and you can even go in for payment system as we go along. I do not want to bore you with that because time is limited, but I'll be delighted if any of you want to discuss that.
In London, there's a virtual firm that does commercial work, and they have very experienced commercial lawyers, and the clients of the firm will identify a key person who they want to run a team, and then the firm will put together a team from the other consultants who are working there. They go to the office of the client to meet rather than the other way around. Seems to work very well. So long as you have enough expertise that you can draw on, then you don't all need to be in the same building. You don't all need to be working for the same firm, as employees. And it seems to work. And I think that one of the things that's going to happen, because office space is so expensive in London, and of course in many other places around the world, that what you're going to have is a sort of semi-virtual system developing, where you will have a core office, but actually people will spend a lot of their time not working in the office, but they'll come together as they need to. I mean, obviously you do need the sort of socialization of people getting together and getting to know each other, building up camaraderie and so on, but you don't need to be in the office all day, every day to do that. And I think there's going to be a sort of hybrid model developing to save money.
Yeah, no, I thank you. I think that obviously it seems as though going forward there's a lot to be said around more bespoke client services, and that's really about being more flexible in terms of using different tools at your disposal to be able to provide those kind of services. Is it like that perhaps in Turkey?
In Turkey, we don't have, those kind of virtual law firms because, it's not it is forbidden actually to. even that I was not able to say much more things about the advertisement ban, but even if I had a newspaper interview about my job or whatever, that could even be considered as just advertisement and so. And this is all valid for the other firms. And even from internet, you can set up. There are some kind of indexation web pages that you can be a member. And currently, the sole practitioners, let's say, in all around the country, we have 29,000 lawyers registered to Istanbul Bar only. Apart from that, the others are registering to those web pages, and they are geographically and depending on their expertise being chosen by the clients, actually. So this is a way of getting the clients for the sole practitioners.
Of course, it's a brilliant way of not losing your female talent after it's had babies.
Actually, the reason that I quit from my old firm was I had twins. 3-year-old twins. I just thought that I would be more flexible if I set up my own firm. But in the beginning, I was naive enough to think about like this. I realized that I had to spend much more time, but after some time, I was able to, have a better life, and I could spend more time with them. And they're only 3 years old. They need my attention, and so it's a good way, actually.
Like a win-win situation, flexible working and bespoke services.
Well, thank you so much for all the contributions. If you are successful in competition, it is important to set high goals, but not too high goals. And one of our goals was that you go out more competitive than you came in, and I think we have achieved that. Thank you.